bikers. Mayotis denies these allegations, and the task force could not corroborate them entirely. Then, several years later in 2002, Mayotis' house in Orangeville, Ontario was raided by provincial police on a domestic assault complaint. They found small amounts of heroin, cocaine, marijuana, and ecstasy tablets, along with weapons, some of which investigators thought may have been illegal.
Ned Mayotis is affectionately referred to by his friends as Crazy Ned. He has seen more criminal charges than any other police officer, he himself being charged, than anyone I can think of.
In total, Mayotis has been leveled with charges from 7 different incidents, including soliciting a prostitute, assaulting a police officer, instigating a road rage incident, and of assaulting women on 2 separate occasions. However, he was convicted of only 1 charge, assault. Ned Mayotis is currently under house arrest. Now to what Superintendent Neely says about Detective Joseph Miched, another detective also on Schertzer's drug squad who was also charged with corruption-related charges. Neely describes how the task force ran an undercover sting operation against Detective Miched. They had an FBI officer pretend that he was involved in a money laundering operation for drug profits. Neely writes in one affidavit that Miched was present and actively participated in several transactions where several hundreds of thousands of dollars of money were delivered to the undercover operator purportedly to be invested or laundered. Miched quit the Toronto Police Force in 2003. He was never charged, and he denies this ever occurred. Christopher Quigley, who we told you about earlier, specifically named Schertzer and members of his crew as being the men who beat him up in 1998.
My life was definitely in jeopardy in that police station, and nobody helped me.
Jim Castles investigated the Quigley case.
I was convinced the allegations that were made were truthful.
The allegations being?
Beaten, tortured, money stolen.
Schertzer and his team say that Quigley's injuries were the result of subduing him after he assaulted them. By 2004, Castles and the rest of the task force felt they were ready to lay charges. They felt they had a strong case against 6 members of the Toronto Police Service. After 2.5 years of investigation by 26 officers, the task force was ready to take the next step. In 2004, the Crown formally charged 6 former drug squad members with stealing from drug dealers, obstructing justice, and in some cases, assault.
When you look at the case and its constituent elements, it's not anywhere near as complex as the Attorney General might have your viewing audience believe it is. It's not.
In the end, there was no trial. The case collapsed, not based on its merits, but because the judge found that the Crown had violated their rights to a speedy trial. As it turns out, that shouldn't have been a surprise to anyone. In fact, a closer look behind the scenes reveals there were obvious problems from the beginning.
It never has been and never will be acceptable for police to engage in criminal activity or take the law into their own hands.
Nearly a year before the charges were laid, RCMP Superintendent John Neely wrote a strongly worded letter condemning the Crown for dragging their heels on examining the evidence that had been compiled. Neely wrote that he remains extremely concerned with what appears to be a lack of any overt action to review our court briefs, review our materials for disclosure, or to work with us to formalize a prosecution strategy. We cannot continue to wait months and months for action on your part. His letter was never replied to.
Here is a very senior investigator charged with the responsibility of investigating and facilitating the prosecution. And he's begging for Crown resources to do their job. He's saying, look, we've done ours. Now the ball's in your court and we can't move forward. He's begging. And they don't even respond to the letter, much less bring in more resources to address the problem.
In total, the evidence against the officers had grown to 1 million pages of documents. Now, once charges are laid, the Crown has to release to the defense, in a process called disclosure, all of the documents relevant to the charges. But in this case, those documents were being released at a glacial pace.
We were getting disclosure in various stages.
Peter Brody was one of the lawyers defending the 6 officers.
3 or 4 months later, we'd return, they'd say, here's another 40,000 pages, and we would say, well, is this everything? They'd say, no, there's a third stage. The clock was ticking.
Did you tell anybody?
In the early stages, I'd say within the first 4 to 6 months, there was a letter that I had written saying, just so you know, I'm not waiving any arguments in relation to delay. So they were on notice.
So you had your eyes on the clock?
But we definitely had our eye on the clock. The prosecution knew we had our eye on the clock. But in fairness to them, I think they were behind the 8 ball. I think they were given a real late start in the game.
Certainly Crown Prosecutor Milan Rupik knew there was a problem. The Crown wasn't getting enough help from the police in delivering the evidence to the defense. In 2006, Rupik wrote a lengthy letter admonishing the task force for not providing enough support. Obtained by CBC News, Rupik said the work to date has been barely satisfactory and that our present situation is dire, that a day of reckoning is upon us. And frankly, he said, I am skeptical the Toronto Police Service is capable of marshalling the necessary resources on a case of this type.
The Crown felt frustrated. They were denied resources. They didn't have enough officers. They wrote some threatening letters saying, we may be forced to abandon this entire prosecution if the Toronto Police Service doesn't come through with support.
Jim Castles agrees with Rupik there was a problem. He says by that time, the task force was downsized. Many officers were reassigned, including himself.
Maybe it was downsized too much. Maybe there wasn't enough resources there to continue to do the work.
That actually, may have jeopardized the case?
Well, it would have made it difficult.
Finally, last year, the defense made good on their warning. The lawyers formally asked the court to throw the case out for reasons of delay. In his decision, Justice Ian Nordheimer said the Crown gave him no compelling reason why the case had dragged on for so long. He complied with the defense's request and stayed the charges.
For too long, the alarm bell has been sounded about the failings in that department. For too long, the complacency has plagued that department.
Julian Faulkner is a Toronto lawyer who's known for taking on the Toronto police. He's also representing Milos Markovic, another one of the alleged victims of police misconduct.
Clearly, the actions on the part of senior officials, be they deputy ministers, assistant deputy ministers, in failing to respond to those alarms effectively, have got to be characterized as intentional.
I don't know the intricacies, I don't know exactly what happened, but the end result is the same. It's just sheer and utter disappointment.
As for the other officers that the task force believe engaged in criminal activity, what's happened to them? Are they still even members of the Toronto Police Service? We tried to get answers to those questions, but the Toronto Police Service refused to give us an interview. Meanwhile, 2 of the officers charged are technically still members of the police service. The Liberal government in Ontario, led by Premier Dalton McGuinty, also refuses to discuss this case. They rebuffed the CBC's request for an interview, saying it's under appeal and therefore still before the courts. But Premier McGuinty did say this just after the case was thrown out.
The result is troubling. That's not a reference to the decision. It's the result itself.
Although some of the government's critics believe it is happy the case collapsed. NDP opposition critic Peter Kormos.
This government is loath to put itself in a position where it's seen to be critical of police or even suspicious of their behavior. And I think that's really regrettable.
There are political issues at play. Allotting resources to the criminal justice system does not win elections.
But if you lose a case like this, and it doesn't go through the court system on its merits, but it's dropped because time ran out, certainly that can't be good for winning elections either.
This is going to fall to the wayside. I doubt you'll be back here at election time interviewing me again. Not going to happen. People will forget about it. They won't be talking about the CFC case come election time, and nothing's going to change.
Is that true? What happens now? The Crown Prosecutor, as I've said, has appealed the judge's decision. Most of the people we talk to in the government and police service are waiting for that decision before they'll talk. However, there is enormous frustration among the people who push the police to deal with these allegations. Some, like Christopher Quigley and Edward Sapiano, the whistleblower in this case, they want to see a public inquiry.